Hello everyone, Namaskar and welcome back to our channel Rastogi-Wellness with Wisdom. I, Rastogi, welcome you all in my channel. Today we are going to analyze a very important service matter concerning the thousands of bank officers and employees of the erstwhile State Bank of Hyderabad and other associate banks of State Bank of India. The case relates to the service condition and benefits applicable after the merger of the associate banks with SBI in 2017. The original case was filed as WP number 8538 of 2018 before the Telangana High Court, which was dismissed by Justice Nagesh Bhima Paka of the Telangana High Court on 20th June 2025. Against that dismissal, 3 officers and the All India State Bank Officers Federation have challenged it and filed Writ Appeal number 855 of 2025 before the division bench, which is currently pending. So, what exactly is the dispute? What benefits are involved? What did the single judge decide? And what are the important grounds now being raised before the division bench? Let us understand the entire matter in simple language. As we all know, the 5 associate banks of State Bank of India were merged with SBI in 2017. In February 2017, the central government issued Gazette notification acquiring 5 associate banks: State Bank of Bikaner and Jaipur, State Bank of Hyderabad, State Bank of Mysore, State Bank of Patiala, and State Bank of Travancore, with effect from 1st April 2017. Clause 7 of these acquisition orders clearly stated that the employee of the transferor banks shall become officers of the transferee bank, that is SBI, and shall hold office on such terms and conditions as may be approved by the Central Board of SBI. However, according to the petitioners, no such terms and conditions were ever approved by the Central Board before the effective date. Instead, just 2 days earlier, on 29th March 2017, the Chief General Manager HR of SBI issued option letters to all employees of the associate banks. These letters forced them to choose option A or B, that is, accept the new terms and conditions, or option C, resign immediately. The petitioners argued that this was completely unknown to service jurisprudence. A permanent employee cannot be forced to resign simply because he does not like the new terms imposed by the management. More importantly, they contended that the Chief General Manager HR had no authority to issue such a letter. Under Section 17, 19 and 43 of State Bank of India Act 1955, the power to appoint officers and frame their service conditions vests only with the Central Board of SBI, not with the CGM HR. It is clear that for thousands of officers and employees, this was not merely a change of employer, it also raised important questions regarding their service conditions, pension, provident fund, and other financial benefits. The petitioners therefore approached the Telangana High Court seeking protection and parity in several areas of service benefits. The petitioners pointed out clear discrimination in the option letter itself. Probationary officers and trainee officers of SBI were given 4 additional increments, while those from the associate banks were denied the same. Special compensatory allowance and special balancing allowance which were being paid to the original SBI officers were specifically denied to the officers coming from the 5 associate banks. They also relied on past practice. When SBI had earlier acquired State Bank of Saurashtra in 2008 and State Bank of Indore in 2010, the employees of those banks were given full SBI terminal benefits, pension, gratuity, and bank's contribution to Provident Fund from the date of their original joining. The officers of the 5 associate banks therefore had a legitimate expectations that the same treatment would be extended to them. Finally, they challenged Clause 9 of the acquisition orders, which barred employees from approaching any court or tribunal, calling it unconstitutional and violative of Article 14. After considering these submissions, Justice Nagesh Bhima Paka dismissed the writ petition on 20th June 2025. While the full reasoning runs into several pages, the core of dismissal appears to rest on the view that the merger was a policy decision of the central government backed by statute that the terms formed part of the approved scheme of amalgamation and that courts should exercise restraint in interfering with such large-scale banking consolidations. The court considered the 2017 merger to be a statutory process backed by the SBI Act, government notification, and the regulatory framework involving RBI. The court therefore did not accept the petitioner's challenge to the merger-related service conditions. The court also examined the argument that employees of earlier SBI acquisitions, such as State Bank of Saurashtra and State Bank of Indore, had received more favorable treatment. The court held that the circumstances of those earlier acquisitions were different from the 2017 merger. Therefore, according to the judgment, the benefits provided in those earlier cases could not automatically be claimed by the employees of the 5 associate banks. The court did not accept the argument of hostile discrimination or lack of authority of the Chief General Manager in the manner projected by the petitioners. Against the dismissal, the same petitioners filed Writ Appeal number 855 of 2025 on 7th August 2025. A division bench headed by the then Chief Justice Aparesh Kumar Singh and Justice G.M. Mohyuddin admitted the appeal in August 2025 and issued notices to the respondents. As of now, the matter is listed before the bench of Justice P. Sam Koshi and Justice Narsingh Rao Nandikonda. The next listing is on 19th August 2026 for hearing. Main grounds likely to be urged in the appeal are the single judge treated the entire matter as pure policy and almost non-justiciable, even though service conditions of employees after a statutory merger remain subject to the test of Article 14. The option letter of 29th March 2017 was coercive in nature. It was a take it or leave it offer that is alien to service law. The Chief General Manager HR had no statutory authority to frame or communicate service conditions. Only the central board could do so. There was clear discrimination in the matter of 4 additional increments and Provident Fund, Special Compensatory Allowance, and Special Balancing Allowance, which violates Article 14 and 16 once the employees became part of the common cadre. The past practice followed in the Saurashtra and Indore mergers created a legitimate expectation that the same terminal benefits would be extended. The single judge relied on subsequent events, such as many officers later opting for pension, which occurred after the writ petition was filed and therefore could not validate the original terms. Clause 9 of the acquisition orders, which sought to bar access to courts, is unconstitutional. So, this is where the matter stands. This appeal will test an important question: to what extent can High Court examine the fairness of service conditions imposed during a statutory bank merger, especially when allegations of coercion, lack of authority, and discrimination are raised? The outcome will have significance not only for the officers of the five associate banks but also for future consolidation in banking sector. What could be the most important document? There is one document that could become extremely important in this litigation: the SBI Central Board's approval or resolution relating to the service condition of the associate bank employees. Why? Because the appeal raises a very specific question: where the disputed service conditions actually approved by the competent authority before they were communicated to the employees. If SBI can demonstrate clear and prior central board approval, the appellant's argument regarding the authority of CGMHR could become considerably weaker. But if there was no such approval, or if the approval came only later, the issue could become much more significant. Our assessment, based on the judgment and the grounds of appeal available to us, I would broadly assess the issue as follows: relatively stronger arguable issues, Central Board authority, Article 14 discrimination relating to Provident Fund, differential treatment concerning special compensatory allowance and special balancing allowance, whether the constitutional test was adequately applied to each individual benefit. More difficult issue is for additional increments because of the earlier Supreme Court precedent, and the argument of legitimate expectations by itself may also be insufficient. The central question is, so what is really at the heart of this case? It is not simply whether the 2017 merger itself was legal. The more important question is, after a legally valid merger, could SBI impose or continue different service conditions for former associate bank employees without a sufficient legal and constitutional justification? And other connected question is, were those service conditions approved by the competent authority in accordance with the SBI Act? These are important questions which the division bench will have to consider in the pending appeal. For thousands of former State Bank of Hyderabad and other associate bank officers, this case is important because it concerns questions of parity, service conditions, and financial benefits following the 2017 merger with SBI. The final outcome will depend upon how the division bench examines the statutory provisions, the earlier Supreme Court judgments, the Central Board's authority, and the specific evidence relating to the different benefits. As per the case records available to us, Writ Appeal number 855/2025 is pending before the Telangana High Court and listed for hearing on 19th August 2026. We will continue to track the developments and bring you updates. If you found this analysis useful, please like the video, share it with your former associate banks colleagues, and subscribe to the channel for further updates on this case and other important issues concerning SBI pensioners and retired officers. Thank you. Thank you for watching. See you in the next one. This video is prepared solely for general information and educational purposes. It is based on the publicly available court records and the order of the High Court for the state of Telangana in Writ Petition 8538/2018. The purpose of this video is only to explain the legal issue and the arguments involved. It does not constitute any legal advice. Viewers are advised to refer to the original judgment and consult a qualified advocate for any legal opinion or action. The content reflects an independent analysis and does not represent the views of any party to the litigation. The appeal WA number 855/2025 is presently pending before the Honorable Telangana High Court.